The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. This is Susan Wortzmans. You're going to be able to identify me from Chuck Rothman, fortunately, by our voices. I'm just going to start and talk about just a couple of housekeeping items. First of all, this webinar is recorded, so if you do need access to it again or miss part of it, you can access it through our office. Second thing I just want to mention is that you can type in questions at any time, and we will see your questions and try to respond to them topically. We're going to have a few minutes left over at the end for questions as well, but if we're talking about preservation and you want to ask a preservation question, ask the question simultaneously, and we'll try to get to your answers as soon as possible. We've also you can also see a slideshow in front of you. That presentation will be made available to you if you want to email Hillary McWaters of our office. We'd be happy to send you a copy of it. Just brief introduction. I'm going to self-introduce. So brief introduction of myself and Chuck Rothman. Many of you know, some of you don't. My background was as a commercial litigator. I worked on several large class actions, securities litigation, and other cases that involved, starting in my career, thousands of documents, then tens of thousands of documents, hundreds of thousands of documents, and millions of documents. And that really led me into developing an interest in e-discovery and how better to manage client information. Wortzmans was started in 2007 with a goal to being a law firm focused solely on advising its clients on e-discovery. Chuck Rothman is a forensic engineer who is at the firm. He's really the go-to person for everyone, certainly at Wortzmans, but also many people at other firms who have technical questions. He has testified many times as an expert witness and is also has a background on some programming, but has an incredible knowledge of all of the e-discovery and information governance tools and platforms that are available to us. So I'm just going to turn to our first slide and talk about some of the tools and the resources that we in the e-discovery world frequently look at, just to make sure that you know about them and have them available. I know that many of you have a lot of experience with e-discovery, so you know about these, but I'll just point out a few highlights. The EDRM, which is the Electronic Discovery Reference Model, and anyone can find that online, is a really, really simple tool and is invaluable to us in our practices all the time. What I typically use this for is trying to explain to a new client what they're about to experience going through the e-discovery process. So when I can take them and walk them through it and say, the first thing we're going to do is identify evidence. We're going to preserve that evidence, collect it. Once that's completed, it will be processed, reviewed, and analyzed, and then produced to the opposing party and ultimately presented at trial. I can walk them through each of those stages in detail as they have this visual in front of them. What's important to me also is to look at the processing, review, analysis steps, which are, not in a row side by side, but they're vertically on top of each other because those three steps interact with each other. So we process, then we review, we do some analysis, then we do more review, and those steps are working together all the time. The same, frankly, with preservation and collection, because once we've done some analysis, we often realize we've missed some certain types of evidence. We need to go back and collect more. We need to preserve other evidence that we hadn't thought about. So again, all of those are working simultaneously. So I would ask clients to pull this up when you're having an initial discussion with them. It's a very easy tool. The Sedona Canada Principles, second edition, are also a really useful guideline, both in terms of the principles themselves and the attached commentary. The principles were first released in January 2008, and they underwent a significant revision and were re-released in February 2016 as the second edition. The major changes to the Sedona Canada principles that you need to know about is that there is the case law has been updated. The original version was in 2008 was really primarily American case law because the case law hadn't developed in Canada. It is up to date as of February 2015 and has a very good background for the Canadian case law. The commentary was also updated to reflect changes in technology and e-discovery software. The new principles also have a real emphasis on cooperation and proportionality. In the new rules, I think the main focus of the proportionality change is that proportionality should generally lead to a narrowing, not an expansion of the volume of e-discovery. Another significant change is that the whole concept of meet and confers that was originally in Principle 4 has now been changed, and I'm going to talk about that more, but it's now called cooperation and collaboration. So I would highly recommend that you look at that as a tool and you look at some of the case law and the commentary as you need to on a particular section. Practice directions. So in Ontario, as many of you are from Ontario, you know that our rules mandate a discovery plan. Other jurisdictions have practice directions that talk about discovery protocols. So it's really important that you know if you're doing a case in Alberta or Manitoba, that you know what their local practice direction says and what their rules say, and they do vary from province to province. The OBA website, if you go into the civil litigation section into e-discovery, there is a case law digest. I've been told that it is updated and that new cases have been forwarded. I looked and I personally couldn't find those cases, but if it's not updated right now, it was updated as of 2014 and there is an update underway, so there should be case law added to that. Also on the OBA website, you can find the e-discovery implementation committee model precedents, and those are really excellent precedents. Most recently, they've added an updated affidavit of documents precedent, and that I think is critical. I know that in the e-discovery world, when you're dealing with a case and you have thousands of records, it's pretty hard to swear an affidavit saying I've looked at everything and I know everything's there. So that has been changed to reflect the fact that counsel should not need to continue to swear that they've looked at absolutely everything to swear that affidavit. And I know that the e-discovery implementation committee is trying to work with the rules committee to have some changes put into place there. So those are the general resources that we look to for background. I'm now going to just turn it over to Chuck Rothman to talk to you about preservation and legal holds.
Thank you, Susan. Preservation is a well-known obligation. Preservation of electronically stored information is covered in Sedona Principle 3. The term document, as used in the Ontario Rules of Civil Procedure and other jurisdictions, includes more than just paper documents and traditional electronic documents such as Word and spreadsheets. It also includes any type of recorded communication, which means it includes voicemails, text messages, audio, video, and pictures. Pretty much anything that's stored electronically is considered a document. The best practices for managing legal holds are really three things. You want to make sure that no information is destroyed, no information that's related to the litigation is modified, and that all of the information related to the litigation remains accessible. The first two are pretty easy to understand, but the remaining accessible needs a little bit of explanation. Digital information in a lot of organizations goes through various stages of storage. They start out either in an email mailbox or on a hard drive somewhere. But a lot of organizations implement archiving and backup in order to save space. Once information is moved to one of these mediums, it's still accessible, but it's a lot more difficult to get. When you implement a legal hold, one thing to keep in mind is that eventually you're going to need to collect this information, and you want to take steps to make sure that the collection process is as efficient as possible to keep costs down. When implementing a legal hold, you want to follow some steps. The first thing you should do is consider any urgent issues that could result in the loss of information in the short term. So this is things like the organization's standard document destruction policies. If they delete emails every 10 days, then you have less than 10 days to get them to stop doing that before emails are gone. You want to make sure that if employees are leaving the organization, that their information is retained right away. And typically, backup routines overwrite backup tapes. You want to make sure that if you need the information stored on backup tapes, that overwriting process is suspended immediately. Once you've taken care of the urgent issues, the first thing, or the next thing you want to do is bring IT on board. IT are not custodians generally, but IT maintains the storage systems. And you want to make sure that they're on board so that any things that they do in the back end to maintain their storage systems won't compromise the information that you need. Then you identify the custodians and the time frame that you need, and you draft a legal hold notice. The legal hold notice should be in a plain language so that non-lawyers and non-technical people can actually understand what you're trying to get across. It should include instructions on what they should do to preserve the information. So if you want them to move or copy all the relevant information to a specific repository, or if you want to tell them don't change anything in these documents, then list it in plain language so that they understand. You also want to make sure that the people who receive the legal hold notices acknowledge that they've received and understood the notice. If after a certain period of time, usually a few days or a week, you haven't received acknowledgments from people, you should follow up and make sure that they've received the notice and that they understand it. You should also include in the notice contact information so that if people have questions, if they don't understand what their obligations are, they know who to contact and they can get answers. Once the notice has been issued and acknowledged, you should periodically send a reminder to them to make sure that they remember that they're still under the obligation to hold the data. The reminders can be every 3 months, 6 months, 9 months, could be annually, just as long as they get periodic reminders so that they remember. And finally, once someone is released from the hold, or once the hold is no longer necessary, you should send notices to the custodians telling them that they no longer need to hold the information.
What I typically find with respect to the release of legal holds, Chuck, is that there's more of an issue with IT not releasing or dealing with that information after the case has been settled. And so it's all been preserved, and there's not really a consideration, does this continue to need to be preserved, or can it actually be disposed of? So I think to add to that, you'd also want to give notice to whoever actually has preserved the information in addition to the custodian.
Absolutely, Susan. That's, IT is a critical part of this whole preservation exercise, and they should be brought in early, and they should be kept informed throughout the whole process, and of course notified when the information is no longer needed. It's important to document all the steps, keep track of the acknowledgments, keep track of the reminders, so that you maintain an audit trail and you have a defensible process. The reason why we need to take these steps, particularly for electronic information, is that electronically stored information is much, much easier to change or destroy than paper information. Some applications, such as Word, may keep records of changes. You can turn on track changes in Word. But a lot of applications, when you change it, you can't really tell what's been changed. So you want to make sure that the information, that you're able to authenticate that the information that you've held is the original information. In addition to the contents of documents, there's also metadata. And metadata can actually be changed very, very easily. The simple act of opening a document will change some of the metadata. Opening a Word document and saving it without changing any of the content will change the last modified date of that Word document. And once that date's changed, you may not know that the content wasn't changed.
And that can actually be important sometimes, because I've certainly been involved in cases where parties have used the last modified date as the actual date of the record. So we've actually received productions where almost every single document has the same date, because they collected it and it was all collected on February 15th, 2016, and that's the date of every single record, which becomes really problematic when they just use the metadata to populate the affidavit of document.
It's also a problem when you're trying to call the data, when you're trying to organize it and sort it out and even call it, because if you have a specific date range, but all of the documents have the date that you've collected it, then you're basically stuck. And finally, if you're not sure about how to preserve electronically stored information, the best thing is to ask some advice. Seek out someone who has actually gone through the preservation process. It can be someone in your firm. It may be your client's IT if they've been down this road before. But seek out someone who's done this before so that they can advise you on the best practices. Now I'm going to turn it back over to Susan to talk about cooperation and collaboration.
So this is one of the touch points that I mentioned that has evolved since the original Sedona Canada principles were released in 2008. Principle 4 was originally about meet and confer, and it actually said the parties should meet and confer to talk about discovery issues. And I think over the years it was acknowledged that that's impractical, and certainly in smaller cases or simpler cases, it didn't make sense for the parties to actually have to meet and confer, and so the practice really changed. So what we talk about now is cooperation and collaboration, and that means having some type of communication with the other side about discovery. That can be emails, that can be phone calls, or that can be meetings, whatever it is. I think that in my experience now, we are seeing discovery plans in almost all of the cases that we work on in Ontario, but in other provinces across the country. And I think these are really helpful because they're forcing us to think about issues early. Things like, do we want to just get some key documents right away from the other side, and can we agree to that? Or are we content to wait 6 months to receive the final production and get, so it's really thinking about, do we want to do a staged production, or do we want to exchange some documents immediately? But these things are important for timing, they're important for settlement, possible settlement of a case. We also think about in this cooperation and collaboration exercise, who should be part of the discussion? Who do you need to reach out to say, is what the other side is saying, is asking me to do possible? How appropriate is it? Does it make sense? And frankly, is it proportionate? Should I include the client or an IT professional from the client in these discussions? So we've been involved in cases where clients have actually agreed to produce records in certain formats that they can't produce them in because they themselves have them in their own environment in a different format or in a database, and I think Chuck's going to talk about that a bit later. So you really need to understand from a technical perspective what information you have and how you can produce it to the other side and exchange it. And so, I'm not talking about the run-of-the-mill sort of emails that we can collect and exchange, but I'm talking more right now about databases and other information. So we've got a couple of questions here. One is, have we ever had a client that does not want to cooperate with the other side in preparing a discovery plan? And the answer is yes. And that's actually a really easy thing to deal with from my perspective, because then I just draft the discovery plan, send it to the other side, and if they don't want to talk about it, I say, well, we're going to assume that these are the rules and these are the guidelines in place. And if you have any concerns or complaints, let me know now, or we'll operate on this basis. And then I get to create my own discovery plan and don't even have to worry about or deal with what the other side concerns are. Not an ideal situation, but when the other side won't come to the table and cooperate, I'll make my own discovery plan and send it to them, so at least I've got something on the record. Have an agenda before these discussions and really get your head around what you're going to talk about, because that will inform who you should have at that discussion, what expertise you need. So, you're going to talk about the timing of the discovery, the format for the exchange of records, when you're going to do that, talk about what fields will be exchanged, what those fields are going to look like, and really having the agenda focuses you to think really carefully and prepare for issues that you will need to have to address.
Susan, do you think that the client should be attending the discovery plan meetings, or should you consult with them ahead of time?
It depends on the complexity, because in certain cases, absolutely not necessary. It's simple. Counsel can deal with it. They can talk to the other side and they can agree on things. But in a complex case where a client is going to be exposed to having evidence collected from multiple jurisdictions, from multiple locations, and it's complicated, and there's going to be dispute about the scope of the discovery, that's when you want your client coming to the table. I mean, really, it's hard to have those real scope discussions without talking to your client before or having them part of those discussions. So the other part that I think is the most important discussion that we're having around collaborating and cooperating with opposing counsel is this transparency issue. And this is a really important question to consider. So what do you want to tell the other side, and what don't you want to tell the other side? The idea of transparency and what to disclose to opposing counsel about one's own process has become an issue in the last year or two, particularly in terms of counsel thinking about what do I want to tell the other side about the technology I'm using and the tools that I'm using. What do I want to tell them about the process that I've developed and how I'm actually validating the results that I get? So some counsel who we work with insist that it's none of the other side's business what we're doing behind the scenes, and we don't have to tell them that we're using technology-assisted review and that we don't actually have humans reviewing documents. They don't want to disclose the fact that they are using TAR, which is technology-assisted review. So sometimes they don't even actually use the tool so that they won't have to disclose that. Others are comfortable to say, I'm using analytics, I'm using predictive coding to analyze a collection and help me determine that I can exclude tens of thousands or hundreds of thousands of records without eyes on review, because the technology is doing that for me. So what do we have to tell the other side? In my view, transparency is a healthy process. What it does is it brings to light any concerns about the approach that a party is taking, and that is important. So often the concerns of opposing counsel may be valid, and they can be addressed by a slight modification or tweak to my process. So if I'm transparent and I say, this is what I'm doing, the other side says, we don't like that, I can fix that problem. So just to give you a concrete example of what I'm talking about, in a case, if I said to opposing counsel, we're going to pull out all the JPEGs and we're not going to review them because they're just likely to be signatures at the bottom of emails and irrelevant photographs. So that's what we're doing, and they know about it. The other side objects and says, absolutely not, you can't omit JPEGs from the review. And I'm thinking, oh great, now I have to add another 75,000 JPEGs back into my review environment. What I really need to know is what's their concern. What do they think I'm missing by excluding JPEGs? When the response is there were a couple of events and parties that people went to that are significant and there may be relevant photographs from that, I can address that by still using technology to exclude some records but not others. Put simply, those annoying email signatures at the bottom of every email can be segregated by finding the MD5 hash value for them and exclude them on bulk, or even based on the actual size of the file of certain types of records, we can exclude those documents and segregate the photographs so they get put into a batch for triage and for review. Having those discussions is actually helpful because it saves me from going through the exercise unilaterally and making a decision that I'm not going to look at JPEGs and then later on have the other side bringing a motion complaining that I haven't produced relevant records that they know I have in my power, possession, and control. So really, if we're careful developing a plan, following that plan, and then validating the results as we go, we should feel comfortable in being transparent, and we should have confidence in the steps that we've taken that will enable us to be transparent with opposing parties.
Okay. When you preserve the data, usually it's done at the beginning of the matter and before you've met to put together the discovery plan. You generally want to preserve broad because you're not entirely sure what all the issues are. But when you come to actually collect the data for review, you want to be as narrow or as targeted as possible. The more data you collect, the more data you will have to work with. And so being as targeted as possible will result in lower costs. The best way to manage a collection is to put together a collection plan. The plan should list what needs to be collected, how to collect from each of the different sources, so how to collect files stored in file shares, how to collect emails, how to collect database information, how to collect off backup tapes if that's necessary. And then you want to document how the information should be stored, if you're going to store it in a separate directory on a server, if you're going to store it on hard drives. You should think about and document security provisions so that if the information that you've collected is highly sensitive, you want to encrypt it, and you may want to restrict access to that information. And finally, you should think about and document backing up the collected data. Once it's collected, you may not do anything with it for several months. And you want to make sure that when you actually need that data, it's in good shape. And if it's stored on a hard drive and the hard drive fails and you've backed it up, then you're good to go. Determining what needs to be collected is sometimes difficult. And what we found, the best method for determining what needs to be collected and where it needs to be collected from is to create what's called a custodian data map. IT people also use the term data map, but their data map really refers to where information is stored. So their data map will show various servers, various email systems, various database systems. But it won't really tell what kind of information is stored on those, apart from emails are stored in email servers. A custodian data map actually tells what kind of information is stored, where it's specifically stored within file servers or email servers, and how long it's stored for. So for instance, a data map will show a file server, a group file server. A custodian data map, let's say for accounting information, will show that the accounting information is actually made up of spreadsheets, and those spreadsheets are emailed back and forth within the accounting department for discussions. It'll also show that the spreadsheets are stored in an accounting group share and that they're kept for 7 years. And having that kind of information will help you zero in on exactly where you need to go and what type of information you need to collect.
How granular does that have to be? That's on a custodian by custodian basis, so you're talking to each of those individuals?
Well, you can create it at a very granular level if you have the information and if you're not talking about a lot of custodians. But generally, the data map is created on a business unit level so that you're looking at the various information that each of the business units create. There's most clients would like to use their existing IT resources, assuming they have existing IT resources, and usually it's to keep costs down. Sometimes they want to use their internal IT resources for sensitive information, and that's fine, that makes sense. But the idea of using internal resources to keep costs down is not always, it's sometimes a false economy. IT resources are really good at maintaining storage systems and maintaining the computer systems, but collecting information for litigation is not something that they're normally asked to do, and there are some different techniques. There's some different considerations that they need to take into account. It's usually best if they want to use their own internal IT resources to have someone who is familiar with collecting information for litigation to advise them on the best practices. And one of the big things where IT tends to fall down on is documentation. IT people usually don't document or don't document very well what they're doing. And having them detail every step that they do in the collection of the data will really help to later on authenticate if it's challenged. One issue that tends to be very challenging for collection is databases, or what's generally called structured data. Structured data is data that conforms to a very rigid structure. So if you think of an address book, you have columns. You have a column for first name, last name, organization, phone number, email address. And you have specific data that goes into each column. You put names in the names column, you put phone numbers in the phone number column, you put email addresses in the email address. You wouldn't put a phone number in the last name column because that would just mess everything up. Unstructured data, on the other hand, is data that you can put anything anywhere. So a Word document is generally unstructured data. You can put whatever you want in a Word document. You can call the file whatever you want. We frequently, when we're going in to collect information, find thousands and thousands of Word documents where the file name is just untitled. And that doesn't really help you. When collecting databases, you need to realize that databases often reside or require specialized hardware and software systems. You can't just copy an entire database file, put it on a hard drive, plug it into your computer, and expect to be able to open it. Databases also tend to be very, very large. There's a term in the industry now called big data, and big data refers to databases. Because they're very large, they're not going to fit on a hard drive, even if that hard drive is a 1 terabyte hard drive. And finally, the organization of data within a structured database is very specific to the design of that database. And unless you know exactly how all the relationships are structured, looking at that information may be meaningless.
One of the solutions to the production, though, of information from a database, which is a practical solution and requires that you talk to the other side, is understand what they actually want, what information they want from the database. Because if, for example, your client is a retail store and they want sales information, instead of handing over the entire sales database, what you may be able to do is say, we have monthly reports about our sales that are circulated to, X number of people in the sales department, and what we're going to give you are these reports that are already generated. And the other side may say, perfect, that's all I need. Or they may say, I don't really want the monthly reports, I need weekly reports, but at least you can then say, I can generate those reports and provide them to you. So having those discussions about that type of structured data is really important. Find out exactly what does the other side need, what do they expect in your production.
The Sedona Conference has put out a database best practices principles. And I urge you, if you're dealing with databases, that you should refer to that. Once the information has been collected, you need to review it. And before you can review it, it needs to go through a stage called processing. And essentially what processing does is it converts all the different formats, the Word documents, the emails, the spreadsheets, the PowerPoints, all into a common format so that you only need one application, which is a litigation support tool, to review the documents. You don't need Word to open the Word documents. You don't need Excel to open the spreadsheets. What processing essentially does is it extracts the contents of each document and indexes it so that you can run keyword searches, and you can also use more advanced linguistic analysis, which is the basis of technology-assisted review, or TAR. It also extracts and indexes all of the metadata so that you can take advantage of that metadata for culling and organizing the information. Once the information has been processed, the first thing that you can do is very easily is generate what's called a data metrics report. The data metrics report will show you essentially what you have. It'll give you the date ranges of all the documents. It'll give you the number of each type of document. If you're concerned about documents in different size ranges, such as what Susan was talking about with the email signatures, it'll give you that information as well. It's a very quick overview of what you have so that you can start making decisions on how you want to organize and call the information. Once it's all processed, you can start grouping the information together for calling or for organizing for review. The first thing that you can do is identify exact duplicates. Regardless of how targeted your collection is, you're bound to have exact duplicates of documents. 3 or 4 copies of an email or 10 copies of a Word document. The processing will identify these exact duplicates, and you can set aside all the copies and just review one copy of the document. You can also, from the data metrics report, look at the various file types and decide which file types you don't actually need to review. So if all you're interested in is email communication and Word documents, any other file type you can just set aside. You can obviously date filter the information to the dates that you need, but you should be a little bit careful about what metadata or computer dates actually represent. For instance, the file creation date is not necessarily the date that the document was created. It usually represents the date that that file was put on the hard drive where it's stored. So if I create a document, if I created a Word document a year ago, but I copied it to a hard drive today, the file creation date is going to be today's date. That's why in most cases the last modified date is the date that's used, because that's the last time the contents of the document changed, regardless of how many times it's been copied. When looking at deduplication, one term you may come across is MD5 hash. And all MD5 hash is a calculated signature based on the contents of the file. And 2 files that have the same MD5 hash can be considered to be exact duplicates. You can also look at more advanced culling methods. One of them is keyword searching. And keyword searching is very easy to understand. Anybody who's used Google knows how to search keywords. But you want to make sure that you're validating your results. Because you're running keyword searches on information that you haven't actually looked at yet, the results you get may not be exactly the results you expected. And so it's good to sample a little bit of what's been hit, and also sample the stuff that the keywords didn't find to make sure that you're actually finding the information you need. You can look at near duplicates. Near duplicates are documents that are almost identical, but there may be a few minor changes. So different drafts of a contract will be near duplicates. And you can group these together, and you can make determinations on whether you just need to review the latest one or you want to review all of them. More advanced culling techniques include conceptual searching, which is looking for documents that talk about the same thing, but don't necessarily have the same content. And then you can get into machine learning and predictive coding, which will help you organize the information. You may be able to call a little bit of it, but more importantly, you can prioritize the information. The computer can tell you what it thinks is most relevant or most likely to be relevant, and you can review that stuff first. Culling is not always just to remove information. It can also be to organize it for review. So for instance, you can create a privilege filter that contains all of the email addresses of the lawyers involved and give that to a separate team for privilege review. And finally, culling doesn't end when the review starts. As Susan will talk about when she discusses review, you should constantly, or the reviewer should constantly be looking for opportunities to identify sets of records that can be dealt with as a group. Now I'll turn it back over to Susan, and she'll talk about lawyer review.
So there's really, the lawyer review is always the most expensive step in the e-discovery process. So on that EDRM, review is usually on average somewhere between 70 and 72% of the cost. So this is where, of an e-discovery exercise, so this is where adopting best practices is essential. So the things I'm going to talk about are the tool to use, how to analyze the collection, the review team itself, what I call taking advantage of the edge, and that's the cutting edge, that's technology, and project management, managing the lawyer review. So you start by choosing the review tool that you're going to use. Often the decision is made for the review tool by, well, we have summation in our office, so we're going to use that. Or we would love to use relativity or ringtail, but they're more expensive, so we're going to use what we have in our office. These are real considerations and real factors that come into play at all different law firms. So from the perspective of choosing the tool, what you need to do is assess, do we actually have the tool that will allow me to accomplish what I need to on this particular file? So for example, if the collection has 200,000 emails, you will likely need a tool that has email threading, because that's going to allow you to reduce the number of emails for review so that you only need to, for example, look at the most inclusive email in an email chain. That may reduce the review, the number of records to review from 200,000 down to 100,000. So yes, you may spend more on a tool that has email threading, but you will save more money on the review side. So that will be a win for your client. You need to analyze your collection and understand the collection and understand the functionality and features of the different review tools that are available. You've got to select the right tool that will allow you to do what you need. My analogy is always, it won't be much use trying to use a screwdriver to hammer a nail into a wall. The hammer will make that job so much easier. And, you know, it's a pretty basic analogy, but you've got to know what kind of a tool you're using and what the functionality is based on your own collection. The collection itself, you need to get your head around that. Chuck did talk about that a bit already, but let me give you an example. Recently, we were contacted by a firm that had a couple of associates review thousands of records from a large collection, and then they came out after and they said, you know, we can't even finish this with the resources that we have. We don't know what to do. So we actually took a look and analyzed what they had reviewed so far and found out that there was an extraordinarily low relevance rate, an inclusion rate. And so that was an immediate red flag to me. Do we really need to have lawyers looking at all those records in that collection? Are they looking at a lot of garbage that could have been extracted and removed electronically? So sometimes we do that by a pilot project, or sometimes we just do it by poking around in the database, and that's typically what we do, to get our heads around what's in there and what types of records can be extracted. If we don't have a high relevance or inclusion rate, we know that we haven't done our job analyzing the collection. You know, in that particular case, are they looking at duplicates of emails? Are they looking at emails that are part of a thread? All those questions came to my mind. So there are many different review platforms that are excellent that have built into them functionality that allows us to analyze the records and use conceptual categorization to put together near duplicates to expedite the review. But whatever tool that you're using as a review platform, you need to have some human input when you're analyzing the collection so that you actually get a better handle on what you're going to need in terms of the manual review. So you need to consider both of those aspects carefully. In terms of the review team, the next key consideration is to decide who's going to conduct this review. Are you going to use 2 or 3 associates in the office who have availability? Are you going to outsource to another firm? Are you going to get assistance from the client? Are you going to send the review to another jurisdiction, to the U.S. or offshore? There are many factors, and cost and quality are 2 of the most important ones. To best manage the file, plan for the review. We start off by trying to understand how many records are going to be published for review. Are we talking about 1,000 records, so it's manageable for the firm to do it in-house? Or are you talking about starting off with 200,000 records for review, which will take 1 or 2 associates the better part of a year to plow through at a snail's pace? You need to assess the volume of records, know the types of records, and get a grasp and understanding of the timing and client needs. If you're responding to an urgent supplementary information request from the Competition Bureau, you probably need a larger team. Do the math. Look at the collection and say there's 50,000 records here. Our team reviews 55 records an hour. That's going to take 900 hours, so where is the manpower going to come from to review those records? Another best practice for the review team is to build a focused and dedicated group. I know from personal experience when I'm doing document review and reviewing records that to the extent I'm distracted and my phones are ringing and I'm doing 10 other things at the same time, my review rate grinds to a halt. It's best to have a dedicated team focused on the matter and the one file. So even if it's an associate in your office, you know, whether it's for half a day or 2 hours a day, they need to actually close their door and focus on review. Also, you've got to do this risk-benefit analysis of outsourcing the review. At your law firm, you may be saying, this is a case that we're working on that is so highly confidential and has such critical information that we can't outsource the review, or we need to put very, very unique security in place. And that's a factor. The risk of the information being released or being in an environment that you're not comfortable with from a security perspective is so high that in the cost-benefit analysis, you're going to spend more money to do that review. And you're not going to send it offshore or to another jurisdiction. In many cases, security is not that significant of an issue, and you can say there's a less expensive alternative, and we're going to outsource the review. We're going to go offshore where we can get lower review rates or to the United States. Consider this lineup of factors and think about, what do I need? Do I need Canadian lawyers, or am I comfortable using other lawyers? Part of that decision-making process is thinking about the collection and the purpose of it and understanding what our client needs are. You may need lawyers looking at the records making relevance and privilege calls, whereas if you're doing simply a review to redact personal information that's objective work, maybe it can be done by non-lawyers. Taking advantage of the edge. So that is the cutting edge in technology. So this is an ongoing process during the review. So you need to involve your associates with doing this. So they're the ones, and the reviewers, they're the ones who are seeing the records, and they have the most information about those records. Leverage and use that information, and then leverage technology to help you find other records that should be pushed ahead to the queue in the review, or frankly excluded from the review. I'll give you examples of both. When an associate comes running into your office and says, or a reviewer, oh, look at this horrible document I found, or look at this amazing document, this is a key document. You want to take that document and you want to say to the review platform, go out and find similar documents to this one, so that you can use conceptual categorization to find other documents that talk about the same concept. You want to get that pile of key documents identified and isolated immediately. You can even extract a specific paragraph that you're really excited about in a document and say, take these words and go out and find other documents that talk about similar concepts. That will help you find your smoking gun faster and perhaps even to the extent that you can settle your case earlier or stop the review earlier. At minimum, you can go to the Senior Litigation Counsel and say, here's some red flags. We need to understand these documents and how to deal with them. Conversely, your review lawyers are seeing every newsletter that an individual custodian has received from Best Buy, weekly alerts that tell him or her about the sales that Best Buy is having. You can then search for the Best Buy domain name and pull all of those records out and remove them from the review set once the client says, yes, there's no possible relevance that these newsletters from Best Buy are responsive. It's important. So, Chuck mentioned earlier that you want to look at domain names to exclude those types of records. Well, we miss them all the time because we don't know what's relevant, what's not relevant until we're doing the review. So it's important to have that communication with the people who are doing the review so they're telling you what they're seeing. You don't want to blindly go through a collection of 40,000 records over 2 months and continue every few days to see the Best Buy newsletters over and over again. It makes no sense. Ask your reviewers to identify the key documents. Ask them for suggestions as to what can be removed. The last point I'm going to talk about is project management. It's actually the most important. Another key factor is having the resources and the ability to properly estimate the review cost for the client and how long it's going to take. There's nothing worse for a client than to get an account from a law firm for tens of thousands of dollars for associates doing document review that was unanticipated. One of the best ways that we predict speed for the lawyers, which will enable us to actually calculate costs, is to do an analysis of the types of records so that are in the collection. So we know from experience that we can review emails very quickly, whereas Excel spreadsheets, PowerPoint presentations, and Word documents are much slower. You were making a mistake if at the end of a collection someone comes back to you and you thought you had 22,000 emails to review that was going to go really quickly, and you calculate that, they're 2 pages long, I'm going to review X number of emails an hour and it's going to take me this long, and then you forget about all the attachments to those emails that are these monstrously long Excel spreadsheets, and you've gone much slower. So the key to project management is also keeping your client informed. You should be able to say, you gave us 100,000 records that needed review. We were able to use technology to identify 50,000 of those records and exclude them from the review because they weren't likely to be responsive. We've sampled those 50,000 records and satisfied ourselves there was nothing statistically relevant in those records that would cause us concern by not having any eyes-on review of them. We are then left with 50,000 more, and then you want to say to the client, it's going to take us 8 weeks using X number of reviewers, and it's going to cost X number of dollars to complete the review. What I don't want to do is call them 6 weeks into that 8-week project and say, by the way, this is actually going to take us 14 weeks and going to cost us triple of what we estimated to you because midway on week 2, you asked us to start redacting confidential information which we hadn't anticipated, and that doubled our cost. Or you've increased the number of issue codes from 10 to 30, and we're now going to go slower. The minute those things happen, you've got to revise your timelines, you've got to revise your fee estimate, and keep that information moving quickly to your client. Give them daily and weekly reports and let them know what the status of the review is. Let them know what you're seeing in the records. Let them know how many are responsive, how many aren't, so you can better analyze the collection. You will be in the best position to estimate the cost of the review, the timing for the review, and to assess what records don't need eyes on if you project manage the exercise. So I'm now just going to turn to briefly to talk about privilege and privacy and what's sort of unique to that in terms of e-discovery. So both of privilege and privacy create unique issues generally because of the large volume of information, but also because of this concept of not having eyes on every single document. That increases the risk that privileged information can be produced to the other side. However, we all know that in both the paper and the e-discovery world, documents that have been carefully reviewed by humans are sometimes inadvertently produced to the other side. This can also happen when dealing with large volumes of electronic information. What that tells us is that neither TAR nor human reviews are perfect. We need to put checks and balances in place to ensure that to the extent possible, privileged communications are protected. The check, of course, is this final eyes-on review of the data set just before it's being produced to the opposing party. And I can't tell you the number of times I have seen collections come in where we think to ourselves, there's no possible way somebody had eyes on this before it went out the door, because what we got cannot possibly be right. The balance is to enter into a clawback agreement with the other side where both parties agree to clawback or immediately return any inadvertently produced privileged communication. We frequently enter into clawback agreements as part of discovery plans or separate agreements when both parties are exchanging large volumes of records with each other. Another issue that can arise with privileged and private communications are redactions. So when redacting certain portions of documents, you want to make sure those redactions actually make their way into the production set. And you also want to think about how to leverage technology when you're conducting the redaction. So there are tools out there. So if you've got a collection that has a lot of personal information, for example, think about auto redaction. Think about the tools that are out there that will actually, if you redact a name in a document, it will automatically redact that name every other time it's in the document. Think about the auto redaction tools that point to certain types of numerical sequences, such as social insurance numbers. So those are automatically redacted. The technology's there, and so when you've got the collection, make sure you're using those tools. And the final piece that we're going to talk to you about is the production.
So once the information has been, once all the documents have been reviewed, it's time to produce them. There's a couple of practices and standards that you should look at. One is Sedona Canada Principle 8. There's various provincial and federal practice directions, and there's also the EIC Model Affidavit of Documents, which has a really good commentary on various issues surrounding production. The actual form of production should be thought about early and incorporated into the discovery plan so that both sides know what they're going to be getting at production time. Production can be in paper, but paper really should be limited to very small productions, or if the receiving party actually requests paper. Some Luddites prefer paper, and so you can give them paper. But generally, productions are done in electronic form, and the electronic form can either be native files or it can be images, text, and fielded information. The issue with native files is that they tend to be hard to redact, and they will contain all of the metadata within those files, and you may not want to produce all of that metadata. So images, text, and fielded data is the common way that electronic information is produced. The images are either TIFF or PDF images. The text is OCR text, or it's text that's extracted from the documents. And the fielded data is sometimes metadata, or it's objectively coded data. In addition to all the standard fields, you also want to include a field that shows parent or family relationships. And finally, you should implement a quality control process to ensure that the documents that you're producing are the documents you actually want to produce.
So I'm just going to ask you, I'm looking at my screen and seeing that some questions are popping up. One of the questions is, and I'm going to turn it to you, Chuck, is what is conceptual categorization, which I mentioned. And we only have a couple of minutes left to answer that question. So I'll say two things before. The next session that we're having on June the 15th is about TAR and technology system review. So we will get that into more depth, but just give the brief answer to that now.
Well, actually, that was going to be my answer. Stay tuned for our next seminar. But conceptual categorization is essentially a process where you give the computer some examples of documents that you want, and it will go out and look through the entire set for other documents that are conceptually similar. Essentially, they look for documents that talk about the same thing.
So it's not keyword searching.
Exactly. There's another question that says, when sampling records, what techniques work best? How do you determine how many records should be sampled? That's actually a very involved conversation, and we're going to be covering that in our next session. So I'm not really going to answer that now. Then there's a final question for you, Susan. Should clawback agreements always be used as a best practice?
The problem with clawback agreements, sometimes, they are a best practice. But I mean, really, under the Law Society rules, if counsel receives privileged communications, they have an ethical, I think, obligation to return them. However, it's good to have this clawback agreement in place because it sets out the process, the timing, how documents will be returned, and that's important. Should they be used in every case? They may not be necessary, and sometimes they're hard to get when there's an imbalance. One party has 10 documents in a class action, for example. The other party has 1 million documents. You're not necessarily going to get that same agreement always. So they are a good practice to have when you can put them in place and get other counsel to agree. So I think that answers. I don't see any other questions popping up. Our email, or my email, is on this last slide. Chuck should be there as well. So if anyone else has other questions that they want to ask us, feel free to send them in via email.